Good afternoon. May it please the court. My name is Dan Whitaker. I represent the appellant in this case, Mack McClung. And at the outset, I'd like to reserve 5 minutes of my time for rebuttal, please.
5 minutes, yes, sir.
The trial court properly determined that Mr. McClung did not breach the operating agreement, which was count 1 of the plaintiff's complaint. The trial court also correctly held that because there was an enforceable agreement, Mr. McClung was not liable under a quasi-contract claim, which was, I believe, count 3 of the plaintiff's complaint. So Mr. McClung is not here today to challenge, and in fact will be asking the court to uphold those rulings by the trial court. The reason that Mr. McClung is the appellant in this case is because the trial court, despite finding that Mr. McClung was the prevailing party on the claims that the plaintiff brought, despite that finding, the trial court determined that Mr. McClung was not able to recover his attorney's fees despite being the prevailing party. So that's what we're...
Is the issue whether the complaint was to enforce the agreement?
That's right. So paragraph 13.5 of the operating agreement indicates that there are two instances or two types of cases where a prevailing party, and it's a fee-shifting provision that goes both ways. It's not one-sided towards the plaintiff. A defendant who prevails is also entitled to his attorney's fees. There are two instances under paragraph 13.5. One, when there is a lawsuit to secure enforcement of an agreement, and second, when there is a lawsuit where a court has to interpret the terms of the agreement. We respectfully submit that both instances are present here. What Mr. Spangler is arguing on appeal, and by the way, Mr. Spangler sought an award of his attorney's fees at the trial court level based on this same language. So this represents a 180-degree turn on appeal. What he says is now on appeal is that, well, the trial court was correct because really only in cases where injunctive relief is sought or a declaratory judgment ruling is sought, that those are the only times a party can be awarded attorney's fees. That's just too limited. That's too limited for what we have here. A court cannot award damages on a breach of contract claim without a judicial interpretation of the contract. In order to determine whether a breach has occurred and whether a party or whether a defendant is liable for damages, the court first has to look and interpret the contract. Interpretation of contract is a matter of law exclusively for the province of the court. It's not a matter of fact, and that's exactly what happened here. The second is that a court cannot award or cannot enter a finding that a contract was breached without without enforcing the terms of the contract. And so, in other words, one can't simply say, I'm not seeking to enforce the contract, I just want damages. In order to get to damages, the court has to enforce the terms of the contract. That's just the basic step that the court has to do. And so we're asking this court to overturn the trial court's denial of Mr. McClung's attorney's fees and to remand it back for the trial court to make a determination of that Mr. McClung can recover his attorney's fees both at trial and on appeal. I'll spend the remainder of my time talking about the issues that Mr. Spangler has raised, because while Mr. Spangler is now claiming that the trial court was correct in its determination that paragraph 13.5 was not a fee-shifting provision that awarded attorney's fees here, he's trying to get this court to overturn the remainder of the trial court's decisions on the merits, and the court should not. I want to focus on 4 key points. And the first is, this is not a new loan that we're talking about. This is not new debt. It's not some new sum of money. No additional dollars changed hands with respect to this amended and restated promissory note. It's
Collateral was exchanged.
well, and we'll get to collateral. There was new collateral because Flintlock LLC was obligated to InSouth Bank to keep the loan collateralized. And so I don't believe it's in dispute that the amended and restated promissory note, which is the subject of Mr. Spangler's grievances, that's the same debt. It's the deficiency balance that remained on the loan originally, or I should say on the original loan. It's the same deficiency balance. It's just the remaining balance. The reason the amount is different is because it's the remaining balance after the foreclosure sale of the Sumner Realty. But it's the same debt. It's the same money. New collateral was provided, and the reason that is the case is because Flintlock was obligated to provide that new collateral. The paragraph 8 of the assumption agreement with release indicated that the loan shall remain secured. And so originally there was different realty. The Sumner Realty was the original security. Flintlock LLC defaults on its obligations to repay. The Sumner Realty is sold at foreclosure sale. There's a deficiency balance remaining. At that point, it's the same debt, but at that point, the debt becomes unsecured. And so, but going back to when Flintlock originally assumed this debt, it was obligated to keep the loan collateralized with any asset of the LLC that it had to give. And the only other asset that Flintlock LLC had to give was the Nashboro Realty. Mr. McClung's authority to provide that, by the way, was explicitly, when I say that, referring to the Nashboro Realty. The written consent explicitly authorized Mr. McClung as the authorized officer to pledge new debt. And what it says is that Mr. McClung, the authorized officer, be and hereby is authorized and empowered to do any acts, including but not limited to the assignment, delivery, pledge, or hypothecation from time to time with lender of any or all assets of this LLC to secure such loan renewals and extensions. What it says is any or all assets of this LLC. And that's what Mr. McClung did.
But what responsibility did the borrower have when the lender could not enforce the note because the statute of limitations had run?
Well, I think that there are two elements to that. The first is the bank could have taken the position that that it was not barred by the statute of limitations, and that because before the purported expiration of the statute of limitations, the bank, InSouth Bank, and this testimony was given by Reed Rayner, his deposition testimony was admitted at Exhibit 10 in full, that the bank's position was that Flintlock continued to owe the deficiency balance, that it was working with Mr. McClung as the authorized officer to get payment for the deficiency balance, and that it was working with Mr. McClung to ensure that Flintlock recollateralized the debt. And that's what the trial court found. The trial court looked at Mr. Rayner's testimony and said that it was trying to do that before the purported expiration of the statute of limitations. And that's the reason we get into whether the statute of limitations even would have barred the bank. We don't believe that it would have. What case law also indicates is that just because a procedural remedy has expired, that doesn't mean that a debt is extinguished. And you saw in Mr. Spangler's response brief, he continuously incants throughout that the debt was extinguished, and that's just entirely contrary to the law. That's not the case. What case law says is that even if a procedural remedy has expired, a debt is not extinguished, a debt remains a debt. So it's still the same loan. It's the same loan that Mr. McClung was authorized to deal with by the written consent. Certainly there was new collateral. Flintlock was always obligated to provide that collateral. And in South Bank in 2015, when it drafted the amended and restated promissory note and the new deed of trust on the Nashboro Realty, the bank drafted those documents and determined that those were necessary and proper to fulfill Flintlock's obligations under the assumption agreement with release. Your Honor, that's my time.
Thank you, Mr. Whitaker.
Thank
We'll
you.
hear from you on rebuttal. Good afternoon, Mr. Panther.
Good afternoon, Your Honors. May it please the Court, my name is Todd Panther. I'm representing Mr. Spangler this afternoon, both in his personal capacity and derivatively on behalf of Flintlock. The fundamental issue in this case is a contract interpretation issue of the written consent. And because it is at the core of really all the issues that you have to address, I'm going to focus my argument on that. The trial court clearly understood the factual context for the written consent. Her ruling, and I'll quote it, she determined that the written consent unquestionably was executed for the purpose of facilitating the September 15, 2011 assumption of Gaillardia's loan on the Sumner property by Flintlock. Where the trial court respectfully lost its way is that she did not apply the factual context to her interpretation of the written consent. And as a result, she interpreted it too broadly, to not be simply the documents that were at issue in September of 2011, but to documents that arose 4 years later in July of 2015. And as we briefed, the trial court and this court should take into account the factual circumstances that existed at the time because it informs the intention of the parties. The words of the written consent are also very important as well. And those words clearly show that the written consent was designed to provide an individual, in this case McClung, with authority to sign those documents in September of 2011. In Section 1, it specifically defines the loan that's at issue, quote-unquote loan, as the existing loan of Gaillardia in the amount of $1,048,000. In Section 2, the authority to execute and deliver documents is tied expressly to the loan, again, the defined term. In Section 4, it refers to what renewals or extensions or other instruments McClung has the authority to sign. And this is very important because the end of that resolution says, in respect to the collateral securing any indebtedness. So it's in the present tense. Nowhere in the written consent does it give Mr. McClung the authority to incur new debts for the company or encumber different property for the company. Mr. Spangler and Flintlock...
The loan, however, required the replacement of collateral. How do we deal with that?
Yes. Well, first off, at the time that the July 15 transaction occurred, 2015 transaction occurred, the deed of trust that had existed had been foreclosed upon. The only property that secured that deed of trust was lost to foreclosure. And by that time, whether you call it an extinguishment of the loan or being relieved from the debt, by July of 2015, Flintlock was relieved of any obligation under the loan. So after all of those events,
You're saying foreclosure relieves the debtor under any obligation under a note?
no, what I'm saying is that as a result of the foreclosure, the deed of trust was effectuated. The property was foreclosed on, which the deed of trust allows. It created a deficiency judgment, and the bank, in South Bank, had 2 years from April 2013 to enforce that deficiency judgment. It didn't. It chose not to. So for the replacement, and to your question, if the bank had enforced the deficiency judgment, if the bank had sought a replacement of the collateral, which it never did, we might be talking about something different. But it didn't. It didn't. We have called it a new loan because whatever Mr. McClung wants to call it, that the remedy was extinguished but the right wasn't, there is no doubt that prior to the July 2015 note, Flintlock had no further liability under this note. And the deed of trust had already been acted upon, and the property was gone. After July 2015, that changed. McClung created a new debt for Flintlock that previously did not exist and encumbered new property that had, prior to that, never been encumbered. And the reason why we think it's fair to call it a new loan is that the 2015 amended note, so-called, was for a different principal amount. It was for a different interest rate. It was secured by different property. And so regardless of what it's called, it is not a renewal or extension of the original note. Remember that in April of 2013, the note still existed. There was a deficiency under the note. There would be no purpose whatsoever in the July 2015 note if it wasn't to create a new debt. From April of 2013 to April of 2015, the bank could have pursued its claim under the 2011 note. It just didn't. The McClung goes through a lot of arguments to try to bring itself within the definition of the authority under the consent, arguing that the remedy was extinguished but not the right. We submit that that's a distinction without a difference. Prior to July 1, 2015, Flintlock had no obligations under the note, no further obligations of the note. Afterwards, it had obligations under a new note. They argue that the statute of limitations was stopped in some way. And this is a very curious argument for McClung to make, because in order to make that argument, he has to represent to you that he duped the bank into believing that it would not be necessary to pursue their deficiency judgment. It is a rare claimant to come in and say, I should be able to take advantage of my misconduct in duping the bank into believing that they didn't have to file suit.
Now, the deficiency judgment after the foreclosure, it was determined the collateral was insufficient to pay off the note. Did a court issue a judgment saying the deficiency is X?
No.
Okay.
No, Your Honor, not at all.
But you refer to it as the deficiency judgment, and I think of a court order.
You should, and I misspoke. There was no judgment whatsoever. There was no judgment whatsoever. The foreclosure occurred in April of 2013. The property was sold at foreclosure, and the sales price at foreclosure was insufficient to pay off the entirety of the note. There was no judgment. The bank never filed any lawsuit. No judgment was ever rendered for a deficiency.
But would not that obligation after the foreclosure sale, would not that obligation have been under the note?
It would have been.
Okay.
It absolutely would have been, and that's our point. That's our point, is that from April 2013 until April 2015, had the bank chosen to do so, they could have filed a lawsuit and secured a judgment for the deficiency, and they never did. They allowed it to lapse, relieved Flintlock of any obligation that at one time existed under the note for a deficiency. And that's where everything would have stood had McClung not signed a new note in July 15, recommitting Flintlock to a debt that it no longer had liability for, and securing that new debt with different property. And we strongly assert that the consent did not give McClung the authority to do that. Other arguments that McClung asserts to try to avoid its obligation or try to get within the written consent is to refer to what he did as a renewal or an extension of the existing note, the September 2011 note. And again, the July 2015 note cannot be fairly characterized as a renewal or an extension of the September 2011 note, when in 2015, that note is not for the same principal amount, not for the same interest amount, not secured by the same property. It is a stretch indeed to refer to that as a renewal or an extension.
If it was not an amendment, then what was the consideration for the new note?
I'm at a loss I'm at a loss to identify any consideration for the new note.
So arguably, that might give rise to a new suit if somebody sued on the amended note.
Potentially. The last point I want to make before my time runs is McClung tries to characterize Spangler and Flintlock as leaving him holding the bag under his guarantee. And what I want to point out on this issue is that McClung's guarantee existed long before Flintlock ever did. McClung guaranteed the original note when it was taken out by his company, Gallardia. And he agreed to continue that guarantee when the loan was assumed by Flintlock. So just like McClung personally guaranteed payment of the loan if Gallardia defaulted, McClung personally guaranteed payment of the loan if Flintlock defaulted. So Flintlock and Spangler aren't imposing any greater obligations on Mr. McClung than what he himself took on. I think, although we assert that the trial court did not correctly interpret the scope of the written consent, as I pointed out in the beginning of my argument, the trial court certainly appreciated who she was dealing with in McClung, and recognized that the effect of the July 2015 transaction that McClung orchestrated was to make Flintlock liable for new debt it did not have, secured by Flintlock property that had not been previously encumbered, and McClung relieved himself of any obligations that he had under his guarantee. So for that reason, we submit with great respect that the trial court erred in its interpretation of the written consent. As to the other issues before you, we think those are covered under our brief, and we'll rely on those. Thank you, Your Honors. Thank you very much.
Thank you, Mr. Panther.
Yep, my pleasure.
Mr. Whitaker, rebuttal.
Thank you, Your Honor. I'm going to pick up right where Mr. Panther left off. This notion that Mr. McClung was doing something so he could, and the term they used in their briefing was Mr. McClung wanted to foist his debt, his personal guarantee, onto Flintlock, and that's just not the case. That's not what the record reflects either. Primarily,
Well,
this
didn't the result of all these transactions relieve him of a personal guarantee?
He was not relieved of the personal guarantee, I don't believe, until the bank was satisfied, which it was when the living trust purchased the note from the bank. At that point, the bank sort of, for lack of a better term, washed its hands of Flintlock because someone else had the debt. This is the money that Flintlock agreed to repay. In 2011, it agreed to repay it. It agreed to keep the debt collateralized with appropriate security. That's what the bank sought to happen. The notion that the statute of limitations, and again, the case law indicates clearly that a loan doesn't cease to exist just because a statute of limitations may or may not have expired. It's still a debt, and it's still the same debt. The other aspect to this was not Mr. McClung foisting debt onto the LLC that was no longer collectible. Both parties testified at trial that neither one of them had any notion that the statute of limitations had run or not. Mr. McClung didn't know about any 2-year statute of limitations. Mr. Spangler never knew about any 2-year statute of limitations. That's an argument that's now been manufactured in order to create a cause of action and to try to characterize or cast this as new debt, which it is not. This is not Mr. McClung trying to foist obligations. What it was is it's in South Bank coming to Mr. McClung and telling them that the bank is not going to forgive the remaining deficiency balance. The bank determined what was the remaining deficiency balance. Your Honor is correct. A court didn't determine that. The bank calculated the remaining deficiency balance.
Well, it was simply math. It was the price bid at the foreclosure sale that's subtracted from the outstanding balance and interest.
Subtracted from whatever payments had originally been made, right? And so just because it's a different, but by the way, this notion that the deficiency balance is a different amount than what is defined in the loan, in this assumption agreement with release, that doesn't hold water, because the first time a party makes a payment towards a loan and pays down the principal of a loan, it doesn't turn it into a new loan just because the balance changed. It's still the same amount of money. It just means that less money is owed than it was before. So this was not something that Mr. McClung foisted. He had no idea the statute of limitations had expired, assuming for the sake of argument that it had. We believe that the bank still would have had a good cause of action, and to foreclose, for Mr. Spangler to argue that the bank did not have a cause of action, and that the bank was not entitled to any kind of tolling of the statute of limitations, is to litigate a hypothetical case that's never been brought to a court. The bank never brought the case to court because it didn't have to. Because what Mr. Rayner testified is that the bank approached Mr. McClung as the authorized officer to get the debt collateralized, and then ultimately to get the debt paid. It worked with Mr. McClung to do that, and the ultimate result of that was these July 2015, the amended and restated promissory note, and then the new deed of trust. By the way, there's never been an argument by Mr. Spangler about how the written consent didn't include paragraph 8 of the assumption agreement with release, which is the requirement that the loan has to remain collateralized. I mean, that was contemporaneously what Flintlock had agreed to do, and it's what both 100% of the membership of Flintlock, Mr. Spangler and Mr. McClung, both agreed that the authorized officer, Mr. McClung, would do. The last thing I'd like to say, Your Honor, is it's not in the record that it's a different interest rate than what was originally the case. We pointed that out in our briefing, but the statement that the interest rate changed in the 2015 amended and restated promissory note, and that it differed from what the original interest rate was, that's just simply that's not in the record. The original interest rate was not introduced at trial.
All right, thank you, Mr. Whitaker and Mr. Panther, for your arguments. We'll take your case under advisement.
Thank you.
Call the next case, please.
Charles F. Holland et al. versus Cheatham County, Tennessee et al.